The journey of the Digital Personal Data Protection Act finds its origin in a 2017 landmark judgment of the Supreme Court of India in the Puttaswamy matter, where the Supreme Court held that right to privacy is a fundamental right of every citizen of this country. The Supreme Court also noted that informational privacy is a facet of the right to privacy and commended to the government to introduce a comprehensive data protection regime to regulate the processing of personal data in the country. Finally, after 6 years in August 2023, the Digital Personal Data Protection Act, or the DPDPA, was passed by the Parliament. It has received the assent of the President and also published in the official gazettes. But the law is yet to come into force, as the rules to operationalize the DPDPA were awaited. Finally, in January this year, the rules were put up for public comments, and we anticipate that within the next few months, the rule will be notified. And based on the statements of the IT Minister, we understand that the government is looking to provide a period of about 18 to 24 months to organizations to transition to this new law, and then enforcement will commence. The GDPR is based on the same guiding principles of other legislation such as GDPR of the European Union and the PDPA in Singapore. The fundamental principles are: number one, lawfulness, fairness, and transparency. Organizations must only process data for a lawful purpose as provided in the law. Organizations must be fair and transparent in their processing activities. Number two, purpose limitation. Organizations can only use the personal data for the purpose for which consent was taken in the first place and for no other purpose. Number three, data minimization. Organizations can only collect personal data which is necessary for them to provide the products and services, and cannot demand individuals to provide data which is excessive or not required. Number four, accuracy. There's an obligation on organizations to ensure that the data is kept accurate, correct, and consistent. Number five, storage limitation. Organizations cannot store data for perpetually. Once the purpose for which the personal data was connected, once the purpose had been served, then within a reasonable period of time, organizations will need to delete their data from their database. Take the integrity and confidentiality. There's an obligation on organizations to ensure that they implement appropriate technical and organizational measures, as well as reasonable security safeguards to ensure that there are no personal data breaches. And lastly, accountability. So the entity which determines the purpose and means of processing of personal data is accountable for compliance and provisions of this law. So the DPDPA is essentially a GDPR-style law, though it's been drafted in a simpler manner and is much less prescriptive as compared to the GDPR. However, there are certain challenges which even GDPR-compliant organizations are likely to face in their journey with compliance with the DPDPA. I think the first problem that comes to my mind is the lawful basis for processing of personal data. Two important lawful bases which are found on the GDPR, which is processing which is necessary for the performance of a contract, as well as legitimate interest of the controller, have not been included under the DPDPA. So essentially, organizations or a majority of their processing operations would necessarily need to rely on consent. And consent, as we know, comes with its own set of challenges and complexity. The other challenge that I believe that organizations are likely to face is regarding notification of personal data breaching. So under the GDPR, there's a risk-based threshold which is provided to determine whether a personal data breach is to be notified to the supervising authority or not. So the GDPR provides that in case a personal data breach is likely to raise a risk to the rights and freedoms of the individuals, then there is an obligation to notify the supervising authority. And in case there's a possibility of a significant risk, then there is an obligation to notify all the individuals whose personal data may have been compromised. However, under the DPDPA, there is no risk threshold provided. So essentially, every personal data breach, no matter how innocuous, no matter whether it raises a risk for the individual or not, would necessarily be required to be notified to each individual whose personal data is compromised, as well as a regulatory authority, which would be the Data Protection Board. So the rules provide that 3 intimations are required to be made, 2 without undue delay, 1 to the board and 1 to the individuals whose personal data may have been compromised. And then an updated detailed report is to be provided. And all this has to be provided to the board within a period of 32 hours. Well, it is just a matter of time that the DPDPA rules are notified by the government, and then a transition period is provided to comply to the provisions of this law. So it is very important organizations today to initiate their data mapping data inventory exercise. A data mapping exercise is essentially deep diving and trying to understand what is the person data that an organization collects, what is the person data that different departments of the organization collects, what are the various source points for collection of person data, what are the various purposes for which person data is used by an organization, how does the person data flow through the organization, who are the third parties with whom person data is being shared. So the data mapping endeavor or the data mapping exercise is the most critical aspect in the journey of compliance with the DPDPA and for organizations to create a culture of respect for privacy within their organizations.